Okay, picture this. You've got a serious problem with your home, you reach out to your homeowners association for some help, and you get nothing. Crickets. What do you even do then? Well, today we're going to unpack a real-life homeowners battle that actually forced an answer, and it reveals exactly what your rights are when your HOA decides to go silent.
So what can you actually do? To figure that out, we're going to follow the story of one homeowner, Laura Braglia. She took her HOA's frustrating, infuriating silence and turned it into a definitive legal victory.
You know, our story starts the way so many of these homeowner headaches do, with what should have been a totally simple home improvement project. Let's get into it. Section 1, a crack in the wall.
So back in October 2023, Laura Braglia is just getting new windows installed. Pretty standard stuff, right? But when her contractors pulled back the drywall, oh boy. They found something that brought the whole project to a grinding halt.
The problem, in her own words from the hearing, severe termite damage. And you gotta pay attention to that crucial phrase she uses, a common wall. Now, if you live in an HOA, you know those two words are everything. They are literally the difference between your problem and their problem.
So based on her community's rules, Ms. Braglia was pretty sure the HOA was on the hook for this, but you can't just operate on a belief. You need documents to prove it. She wasn't trying to start a big fight here. She was just trying to figure out who was liable. And that one simple request, that's where the real trouble began.
Which brings us to Section 2, the paper trail. With a massive repair bill looming, Ms. Braglia did the smart thing. She moved to get the information she needed through official channels, and in the process, started a paper trail that will become the absolute center of her case.
On November 28, 2023, she sent a formal request for 3 key items. First, all the termite records from the last decade that show if the HOA had been slacking. Second, a copy of the termite warranty to see what's covered. And third, the HOA's insurance policy. That's the roadmap for getting the damage paid for. This was a clear, direct, and most importantly, a documented request.
And this, right here, is the legal heart of the whole matter. Under Arizona law, an HOA can't just ignore you. The statute is explicit. They get 10, count 'em, 10 business days to provide requested records. That's not a suggestion. It is a hard deadline.
And just look at this timeline. The request goes out November 28th. The legal deadline passes on December 12th with total silence. A month later, still nothing, so she's forced to file a complaint with the state. It wasn't until February 13th, we're talking nearly 2 months late, that the HOA provided even a partial response.
Okay, Section 3, inside the hearing. Now that a formal complaint was filed, this thing was way beyond emails. On April 12, 2024, it escalated to an administrative hearing where both sides had to show up and make their case in front of a judge.
So let's set the stage. On one side, you've got Laura Braglia, the petitioner, and she's representing herself. On the other side is Jacqueline Ziprick, representing the Palo Verde Estates HOA. And right in the middle, you have Administrative Law Judge Jenna Clark, whose job it is to sort this all out.
The arguments pretty much boiled down to this. The homeowner's case was dead simple. The HOA broke the law by missing the 10-day deadline, period. The HOA's defense? Well, it was a list of excuses. The request was kind of unclear. A key document she asked for doesn't actually exist, and, they had some technical issues and email problems.
And this is where the judge made a really crucial clarification. She basically said, look, we are not here to talk about termites or damage or who has to pay for the wall. The only issue on the table is a procedural one. Did the HOA follow the law for records requests? Her job, in her own words, was to be exceptionally rigid on that one single point. So let's get to it. Section 4, the judge's final word. After hearing from both sides, the judge, focusing only on that narrow, rigid question of the law, prepared her official decision. So with all the arguments laid out, who was right? Did the HOA's list of excuses for the delay hold any water, or did this simple, black and white fact of the missed deadline win the day?
Well, the answer was clear, and it was decisive. The judge granted the petition in favor of the homeowner, Laura Braglia.
And the final decision was blunt. The judge found no viable justification or excuse for the HOA's inaction. In other words, it didn't really matter if the request was perfect or not. That 2-month delay was completely inexcusable. So what were the consequences? First, the judge ordered the HOA to comply with the 10-day law from now on. Second, and this is a big one for homeowners, the HOA had to pay back Ms. Braglia's $500 filing fee. The judge decided not to add any extra civil penalties, focusing instead on reimbursement and making sure they follow the rules in the future.
Okay, final section, Section 5, Lessons for Homeowners. So, what are the key takeaways from all this? Because really, this case provides a super clear roadmap for any homeowner who's facing a silent HOA.
Here's the 4-step playbook this case teaches us. 1. Put it in writing. That clear, dated paper trail is your best evidence. 2. Cite the specific rule. Show them you know your rights and that you know their deadline. 3. Follow up methodically. Note the deadline and the day it passes, send a follow-up. It shows you're serious. And 4. Know the formal process. If they still don't respond, don't just get mad, use the official state process. This methodical approach is what turns frustration into actual results.
You know, this entire case really boils down to one final question for every single homeowner out there. An HOA is supposed to maintain the community and serve its members. So take a second and think about your own. Is it transparent? Is it responsive? In short, does your HOA work for you?